Supkem stands by its earlier position that following the historic protest by GNCs that pricked the conscience of our nation, the country needs to have a very serious conversation with itself in order to ensure that the genuine issues raised by GNCs are addressed comprehensively and with finality. This statement is actually responding to the petition case that has been filed by a group of Kenyans, led by one good friend of mine, Cyprian Nyamwamu, and others. And let me begin by saying Bismillahirrahmanirrahim. The court order of Honorable Bahati Mwamuye, dated 24th July 2024, appertaining to the above reference case filed at the High Court of Kenya at Nairobi by Cyprian Nyamwamu and 13 others, has been placed in our hands, the substance of which is that the Supreme Council of Kenya Muslims has been cited as the 14th interested party to the case and is required to file a response to the application thereof by 16 August 2024. Pursuant to the said court order, the leadership of the Supreme Council of Kenya Muslims wishes to state that as much as we acknowledge and appreciate the constitutional right of Mr. Cyprian Nyamwamu and his fellow petitioners to pursue the course of action stated in the application, we in Supkem wish to disassociate ourselves with this court process because we were not consulted before being enjoined as an interested party. We wish to point out that the Constitution of the Supreme Council of Kenya Muslims provides that for the society to pursue such a court case, the issue must be tabled before the relevant organs of the Council and a decision taken following appropriate processes. In present case, the relevant organ of the Council was not consulted before the Council was committed as an interested party. In this regard, we reiterate as follows, that the Supreme Council of Kenya Muslims distance itself from the case filed by Nyamwamu and 13 others on grounds that we were not consulted and that Supkem is incapable of filing a response in its own name. 2, the leadership of Supkem will approach the Honorable Court, says on this matter, to have Supkem discharged as an interested party. However, it is our position that the issues raised by GNCs cannot be addressed outside the structure provided in our Constitution. In holding this position, we are guided by the provisions of Article 2 of the Constitution, which holds, among other things, that no person may claim or exercise state authority except as authorized under this Constitution. Further, our position is in support of structured and all-inclusive dialogue to address the pertinent issues raised by GNCs is anchored in Article 10 of the Constitution on national values and principles of governance, which include, among other things, the rule of law, democracy, and participation of the people. In this regard, we urge those who are opposed to the dialogue to rethink their stand and embrace the call for an inclusive national dialogue. But we also call upon the political class not to use the opportunity for dialogue to entrench their vested interests in the expense of the well-meaning grievances and raised by our young people. Above all, we cannot proceed with dialogue without justice for the innocent lives lost during GNC's protest, and without holding the relevant duty bearers accountable for the physical and psychological trauma suffered by those who are maimed, abducted, and illegally detained in said response to the youth protests. Thank you. And signed by myself.